Very good evening, viewers. Solicitors Ahmed with you. I'll give you some important update about EU citizen and their family member with limited leave to remain or pre-settled status, whether they can claim benefit. An important update, including right to work of asylum seeker and the new immigration rules, which introduced by the Home Secretary last month. So stay with me, and if you have any question in relation to immigration or family, you can call me to the number appear on the screen. That is 0203 2395976. So you can call me, or you can text me at the WhatsApp number appear to me on the screen. Stay with me, and I'll come after a short break with all these questions and answer. Thank you very much, viewers. First question is whether EU citizen with limited leave to remain or pre-settled status claim benefit. This is an important question because generally under the immigration rules, which is applicable for non-EU citizen, EU they cannot claim benefit or their BRP side itself, no recourse to public fund. The question is whether EU citizen, as their leave is limited leave to remain or pre-settled status, can claim benefit. Government try to brought a regulation or law to stop claiming benefit or some sort of obstacle in terms of whether people, EU citizen and their family member with leave to remain, limited leave to remain, can claim benefit. They basically what the regulation they brought to showing that government brought in a regulation that stopped people with EU pre-settled status from simply showing that the DWP as a proof of their right to reside in the UK. Simply people with pre-settled status can still can claim benefit, but have to jump through all sort of hoops to establish their right to reside. So basically, some sort of obstacle or restriction to prove the right to reside to the DWP, which the government tried to bring the regulation. However, this was being challenged by a case which is name is Fatila and Vanessa versus Secretary of State, Work and Pension 2020. This is a very recent case, and this case, Court of Appeal ruled that if not successfully Home Office, the government DWP appeal against the decision that EU citizen with pre-settled status or limited leave to remain can claim benefit. So those EU citizens and their family member who were confused whether the limited leave to remain holder or pre-settled status holder can claim benefit. Now it is clear that those EU citizens who has limited leave to remain, they can claim public funds or benefits, accommodation, universal credit, child benefits, so all the public benefits, what is available for a British citizen, everything that's all sort of benefit can claim by EU citizen under this case. Now government cannot put any restriction or obstacle to claim benefit. So this case, which is Fratilla and Tenesa versus Secretary of Work and Pension, is clear. The ruling is clear that EU citizen will able to claim benefit if they need. So it's a very important case. Otherwise, thousands and millions of EU citizens who came in this country up to 31st December 2020, they would not able to claim benefit. Somehow, as EU law is no more in the UK, somehow some sort of regulation could introduced by the by the government to stop EU citizens to claim benefit. However, before Brexit, fortunately, the court ruled that EU citizen with pre-settled status can claim benefits. So it is clear now. Thank you very much. So to the court for a wonderful decision which cleared the confusion and stop the government to bring the regulation to stop EU citizen to claim benefits or to put some kinds of restriction or obstacle. So this is important update for EU citizen, and then I'll move to asylum update. So this is also, if you have any question with regard to EU citizen, whether EU citizen can claim their family member in the UK, whether EU citizen still able to come to the UK, you can call me at the number appeared on the screen, or you can text me. You can write a comment below my live video, and I will try to give your answer of our live session. So the next question is very important update for asylum seeker. Asylum seeker, when someone comes to this country, they face lots of obstacle. They come in this country with empty hands. Almost 99% of the asylum seeker, they come with empty. They don't have money. They don't have place to live. So the regulation make it easier for them to claim accommodation, to apply to the Home Office for right to work. But in many cases, Home Office refuse a right to work, or if they issue right to work, they give to work on a shortage occupation list. Means those asylum seeker who has received or who will receive right to work from the Home Office, they can work only a shortage occupation list. Means Appendix K, there is a list of shortage occupation list which is available for skilled worker. So this is basically for doctor, engineer, nurses, some kind of level 6 or above graduates, skill job. Unfortunately, asylum seeker, most of the asylum seeker are not qualified to do this, to do these types of work. They can do a law job in a factory, warehouses, these types of work can do. So although the law allowed to asylum seeker to work when the Home Office give permission, but because of the limitation that they can work only on shortage occupation list, the asylum seeker cannot work. This matter come to courts. This matter was challenged by a case which is very reputed case, but recently the court gave the judgment with the case name is R.I.J. Kosuba versus Secretary of State Home Department. I'll take a call, and after that I'll continue. Hello.
Hi. I just see the for the immigration advice with this number.
Yes, please ask your question, brother.
Sorry?
Yeah, you can ask your question.
I have to ask text.
No, I say, what is your question?
Oh, sorry. My question is, I have the EU settlement. Hello?
Yes.
Can I hear me?
Yeah, I'm hearing you. Go ahead.
Can I hear me with that?
Yes, brother. Ask your question.
Yeah, because I have the EU settle. I mean that I have the settled status here.
Yes.
And my missus, she's a pre-settle now.
Okay.
So what happened is now, because I am now I'm in permanent resident here, ILR in independently, because my missus is pre-settled, because still she has with depend with the household depend with my uncle, because we both of we are Eastern family members. So can I get for the benefit from government? I can get it by my missus, how she can get the benefit.
Right. Both of you can claim benefit, no problem. That's what I gave the update. Now, because the following the court decision, it is clear that EU citizen or non-EU citizen having pre-settled status can claim benefit now. That's what I gave the update. All right. Now, because the following the court decision, it is clear that
Hello.
Yeah, Brother, you can drop the call. I gave your answer and I'll give you again. All right, thank you.
Hello.
Yeah, brother, thank you very much. I'll give you an answer. Hope you are watching me. EU citizen who has settled status or pre-settled status, they can claim benefit now. So if you need any help due to the COVID or for any circumstance, if your earnings is not enough, you can apply for universal credit. Whether you are EU citizen or non-EU citizen, as soon as you have pre-settled status or settled status under EU settlement scheme, you can claim. If you don't have the status yet, for example, if you recently moved to the UK, still you can apply, and you can apply for pre-settled status. In the meantime, if you need any help for public funds, you can make the application. There is no restriction for EU citizen. This is the different what I explained for the limited leave to remain, because generally limited leave to remain in immigration law, they don't have access to public fund unless the Home Office give you a fee waiver or accept subsequent any application. Thank you very much for your question. I'll continue to asylum seeker. What I said that EU citizen, excuse me, the asylum seeker right to work. So in this case, the our Kosovo versus Secretary of State Home Department. This is a very recent case, which is 2020. I think in December or November or December, this case came. In this case, the Home Office policy on permission to work for asylum seeker is unlawful. That is to the extent that it doesn't allow for potential victim of human trafficking or the to right to work in the UK, or also the High Court held that the policy will now have to be reworked to make it clear that there is a restriction to allow asylum seeker to work in non-shortage jobs. That means right now, the Home Office didn't change their policy yet, but the court position is that the Home Office policy for right to work for asylum seekers should be reformed so that it allow to work for the asylum seeker on non-shortage jobs. For example, in warehouse, in a taxi driver, or in a restaurant, or jobs. So this non-skill work, so that the asylum seeker can work. So this is very important. Hopefully, this year Home Office will reform their policy following the judgment from the High Court, and which will allow the asylum seeker to work in a no shortage, no unskilled jobs. It is also held that in that observation and analysis that the Home Office also don't normally give initially when someone seek asylum. This also should reform that the asylum seeker should get right to work as soon as possible, because until or unless get the decision, the financial help given by the Home Office is not sufficient to survive someone in the UK. So this case is very important. I hope in near future more cases will come about the right to work of the asylum seeker, because sometimes asylum decision take ages, 2-3 years, and 2-3 years someone having no right to work is very difficult to survive in the UK. So let me take another call and I'll come back after that. Hello. Ages, years, and 2-3 years someone having. Hello.
Hello.
Yes, please ask your question.
Hello.
Hello.
Yes, I want to ask a question.
Please.
Okay, like I've got derivative rights. Yeah.
Yes.
Then I applied for pre-settled and they gave me pre-settled, but they said I can't claim then. So I don't know if the new laws says we can claim now because I've got the rating right before and I applied for pre-settled and I was given pre-settled.
Okay. So you are the carer of a EU child, isn't it?
Huh?
Was you carer of a European child?
You say what?
On what basis you got derivative rights?
I'm a parent of a British citizen.
Okay, you are a parent of a British citizen.
And I was given derivative 4 years ago. I'll be 5 years July.
Mm-hmm.
And I applied for EU settlement scheme last year, and they gave me the pre-settled. But last year they said I can't go for benefits.
No, you can claim benefit.
Sorry?
You can claim benefit. Okay.
The line is not clear.
Okay, drop your call and I'll give your answer live. Okay, continue to listen.
Yeah? Hello?
I said drop your call and I'll give your answer live. Thank you. It is also very important, the question she asked. So basically, derivative rights is basically derived from someone else. So if someone is a carer of a EU child or British child or a British citizen, in that case, if the relationship break up or if someone else die, then the carer will have derivative rights. However, the carer will have right to reside in that respective EU country, which is derived from that British child or derived from that EU child. So you can reside, but the problem is if you complete 5 years in the UK on the basis of your derivative rights, you cannot claim permanent residence under the EU law, the same as what settled status. So as it is a limited leave to remain, again, this is under the this is a limited leave under the case law because it is not a fully EU free movement rights or family member rights, and that's a reason where someone cannot claim benefit. However, if your circumstance is exceptional, if you are a destitute means if you don't have enough earnings to pay your bills, to pay your rent, to pay to buy food for your child, buy food for yourself, to pay rent, utility bills, then you can ask the Home Office to give you access to public fund. So in your BRP card, because it said EU derivative rights, no recourse to public funds. So what you should do, you need to make an application to the Home Office to give you access to public funds. During this pandemic, a lot of application for fee waiver and access to public funds accepted by the Home Office because a lot of people are struggling to survive. A lot of people lost their job. They don't have access to public fund. They cannot pay the Home Office, cannot pay the rent. They cannot buy the food. So what the Home Office guidelines is that they are helping to people who need help. So, madam, if you need any help, probably the Home Office or DWP or the job center refuse to give you public funds or the universal credit, you can make an application to the Home Office separately to give you access to the public fund. This application is a bit technical, but if you can help, if you can seek help from any nearest citizen advice bureau, they are helping over the telephones. You can call them. They will help you to fill up this application if you cannot do by yourself. So what you need to fill up the form and you need to show how much you earn and how much the expense. And if your expense is more than your earnings, most probably Home Office will change the condition and they will give you access to public fund. And then hopefully you have a good time with your child, inshallah. Thank you very much for your question, viewers. Solicitor Suhail Ahmed, I'll give your answer. If you have any question, you can call me. The number appear on the screen. Alternatively, you can write a comment, or you can text me at my WhatsApp. I will give now all the answer from Facebook Live comment. Stay with me. I will come after a short break. Hello.
Hello, can I talk, Mr. Sohail?
Yes, speaking. Hello.
Assalamu alaikum.
Brother, ask a question.
Hello.
Yeah, do you hear me, brother?
Sorry, I can't hear you. Mr. Sohail speaking.
Yes, Mr. Suhail is speaking. I'm speaking. You can ask your question.
Yeah, sir, can I talk in Urdu if you don't mind?
Yes, please.
सर 2020 जनवरी में मैंने सेक्शन 120 का होम ऑफिस ने मुझे लेटर भेजा था, उसका मैंने रिप्लाई किया था उनको। वो कह रहे थे मेरी पार्टनर है, उनसे मेरी ना बेबी है, ठीक है, 4 ईयर ओल्ड। उनके पास है EU रेजिडेंस कार्ड है जो उनको उनके बेबी के बिहाफ पे मिला हुआ है, ठीक है। तो नियरली 1 ईयर हो गया, फुल 1 साल हो गया मुझे उनको डॉक्यूमेंट्स प्रोवाइड किए हुए हैं, एंड स्टिल आई एम वेटिंग फॉर माय डिसीजन। एंड मैंने उनको लेटर भी लिखा है, तो कोई रिप्लाई नहीं उनका आया। पूरा 1 साल हो गया मैंने उनको अपने सारे डॉक्यूमेंट्स सेंड किए हुए हैं। तो इससे अभी इसके क्या ऑप्शन है, मैं क्या कर सकता हूँ? इसमें कोई ऑप्शन है मेरे लिए?
आप क्या एप्लीकेशन कर दिया?
सॉरी,
ह्यूमन राइट्स एप्लीकेशन कर दिया, वो अंडर EU लॉ?
नहीं, वो सेक्शन 120 का लेटर नहीं जो होता, वो उन्होंने मुझे भेजा था।
ठीक है,
हमें सेंड करो अगर तुम्हारे पास कुछ है तो।
1 साल हो गया, आपको कुछ नहीं रिप्लाई कर रहा है होम ऑफिस वाला? ठीक है, मैं आप कॉल ड्रॉप कर सकती है, मैं आपको क्वेश्चन आंसर दे दूंगा इंशाल्लाह लाइव।
ओके, थैंक यू वेरी मच, थैंक यू।
Thank you, brother, for your question. Many people face this problem, and previously I update in my live video, because home office sometime they lost the file. Sometime what they do, a caseworker maybe thousands of files she is working or he is working, and the file drops somewhere else, and the applicant cannot get an update. So in that situation, what you should do, if you write already letter, you call them, it's not working. So last option, what I advise, and it's very effective and free of charge. That method you can use. I believe most of my client or most of the people get response within 2 months. Within 8 weeks, you will get a response. For example, I got and face some people who is waiting nearly 1 year, 2 year home office, following that 120 notice reply, or following their further submission or asylum application, home office is not replying anything. In that case, the last resource, what I advise, don't go to court, because court proceeding is very expensive and it will delay another year. So rather than go to effective method, and it's free of charge. So brother, what I'm saying, I hope you'll understand that for my viewers' advantage, I'm giving you answer in English. Contact your local MP. Tomorrow, Google it wherever you live, your local MP, secretary of your local MP, and send an email to your local MP. Normally, MP doesn't have, you will not get the contract, but there is an email you will get. So Google it, your local MP office, and then send an email explaining your situation. Tell them that I'm waiting for nearly a year for the reply of my 120 notice. And this is the reference number. This is my name. This is my date of birth. And home office not replying. I'm waiting for 1 year. So can you please send home office an email and ask them to give me a reply? Then the MP secretary will contact with you. Maybe they will call you, or they will email you, or give your mobile number on your email. They will call you and they will ask you what is the situation. And then the secretary of your local MP will send an email to the Home Office. In Home Office, for the MP, they have a separate section where the MP send an email, and on a priority basis, Home Office reply you, because this is the inquiry from a local MP, and if they don't give reply, the MP will next day raise this issue in the Parliament. So there is a separate section. Then what the Home Office will do, when the MP send an email, then the Home Office officer or caseworker, whoever it is, will find your file, and they will start work on your file and give a prompt reply to the MP. So brother, call or send an email to your MP, explain your situation, and then hopefully within 8 weeks, you will get a reply. If you get a reply, send me a message, and I hope I'll be happy if you hear something from you. But trust me, this is a very effective method. You don't need to pay any cost. If you go to a solicitor to ask to write a letter, of course, solicitor, like our professionals, we have time which is we need to calculate other cost, and we'll charge you. So rather than go, which is if you go to your MP, send an email by yourself to your MP, and MP will send an email to the Home Office, and you'll get a response within 2 weeks. Thank you, brother, for your question. Let me take the answer from a live comment. So if you have any question, you can call me, brother, or you can write a live comment. I'll keep continue give the answers. Let's first comment, Olari Joseph. What about non-EU with pre-settled status? I think you asked me a non-EU citizen with pre-settled status whether they can claim benefit or not. That's what was my first update. Yes, any EU citizen or non-EU citizen who has who exercise EU rights, EU law, EU rights under EU law, and subsequently they have received pre-settled status under the EU law, they can claim benefit from the public funds if they need. Jamal Ansari, one of my top viewers, and I think I appreciate for your comment. I'm an asylum seeker. I have right to work, but I cannot have bank account and NI number. I can't pay tax, or I cannot do right job. Any option to get bank account and NI number? Brother Jamal Ansari, unfortunately, government made a regulation, law in 2014, which basically closed a lot of, make a lot of restriction on immigrant. That is right to work, right to rent, that is right to open a bank account. So if you do have an ID and proof of address, probably you can open a bank account, you can try, or there is an online bank account, Manoj, you can try over there. And the right to work, I know it is limited to a shortage occupation list. However, the case law, what it is came, the Home Office hopefully will reform their right to work policy for asylum seeker. And then if they change it, then hopefully you can ask the Home Office to change the permission again, and they will issue a new permission which will allow you to do any work. A national insurance number, again, unfortunately, you cannot claim right now. I think you don't have an ID now. If you do have an ID, you can try the Home Office, try to take a national insurance number. But right now, most of the appointment being cancelled for the national insurance number, and until the lockdown is or cancel or everything get normal, and unfortunately, you're not able to get the national insurance number. Tessa Rangasmai, an asylum seeker, can I work? Yes, but you need to take permission. You need to get permission from the Home Office. So you need to make an application to the Home Office. This is a very simple application. You can do it by yourself. If you go to a Home Office website, find a form, fill up this one, send it to the Home Office. And if the Home Office write you by a letter and give you right to work, then you can work. Otherwise, you cannot work by yourself unless you get permission from the Home Office. Dubila Max, are they still doing screening interview for asylum seeker? Following the first lockdown, they have started taking some interview, but again, they stop it. But right now they are taking some asylum interview, screening interview over the telephone. So I'm not sure about your situation. If you need, you can call to the asylum hotline, and the asylum, there is a phone number available at the home office, and someone will help you. Tessa Rangose, I have been waiting for nearly 2.5 years and I haven't had any substantial interview. This looks like not okay. Normally within a year, normally 6, 7, 8 months in standard time, the call for a substantial interview. Substantial interview is very important. But anyway, Tessa Rangasmai, you can apply for a work permit from the Home Office because it's 2 years. You can apply. If you apply Home Office, it will give you right to work because your application is pending for a long time. This is not a normal. 2.5 years is not normal. Normally within a year, Home Office make a decision. So you can apply to the Home Office for right to work. I think you will get a work permit from the Home Office. Jamal Ansari, do you have solitaria? I don't know. What do you mean, brother? I'm a solicitor, yes, if you ask me. And next question. Yes, I see. Tessa, who was told to wait as everything is being postponed because of pandemic. That's correct. Mr. Jamal Ansari, you are doing well. You are advising the client and the people. You are very helpful. Jamal Ansari, thank you. That's great. Actually, sometimes patient become more familiar with the medicine, and he can advise some people. So you are advising them as well. Jamal Ansari, thank you. Next question. Mami Oswa, can pre-settled status holder get benefit, please? Yes, pre-settled status holder can claim benefit. There is no restriction. So you can, if you need help, you can contact to the Home Office. You can contact the DWP and apply for benefit. Next question. Ahmed Ali Suri, will EU citizen be able to travel and stay in the UK? Brilliant question. EU citizens who already in the UK, they have before who moved 31st December, they have right to work, they have right to claim benefit, they can do everything whatever they used to do under EU before Brexit. Those EU nationals who never came in the UK, who doesn't have any status under EU settlement scheme, for the first time comer, British national, EU national. The question, can they come to the UK without a visa? Yes, EU citizen can come to the UK, or British citizen can go to the Europe without visa for 3 months. So still there is no travel restriction that you need visa. Without visa, EU citizen and the British citizen can travel throughout the Europe and UK. Continue to give answer. Let me take one call. Hello.
Hello.
Yes.
Hello.
Please ask your question, viewers.
Yeah, I'm an asylum seeker and I got married recently, but it's not registered yet. So can I able to apply for visa in this country for settlement, spouse visa? Is it possible?
Have you received? Did the Home Office accept your asylum application? Hello. Unfortunately, I lost my caller. Probably you asked me that whether you can bring your spouse. You are a asylum seeker. Now, if the Home Office accept your claim as a refugee, then you can bring your family under the family reunion rule. You don't need to pay any Home Office fee. Just what you need to prove that your relationship has started before you left your home country. You can bring your family, you can bring your dependent children, so you can bring them in the UK under the family union rule. If your asylum application is pending to the Home Office, then you cannot bring your family in the UK, whether your spouse or your children, because you don't have a leave to remain yet, because Home Office may refuse your application. But if they accept in future, you can bring them under family union route. I hope you got your answer. If you do not get my answer because I cannot get your question clearly, you can write a comment or you can come back and call me again. Thank you very much for your question. Now, next question. Lubna Hamid, can EU citizen bring his wife from EU to UK with not visa? That's absolutely correct. EU citizen can bring their spouse from EU or from non-EU country, or from their children from anywhere, anywhere, if they come to the UK before 31st December and applied for pre-settle or settle status. They still have time up to June 2021 to make this application, and they can bring their family member under the EU law, under the EU settlement scheme. So those who EU citizen who already move in the UK, they can bring their EU spouse, they can bring their children, whether from Europe or from outside the UK, under the EU settlement scheme, same as before 31st December 2020. I hope you got my answer. Dubila Max, you asked me, Jamal Ansari, what is solicitaria? Actually, brother Dubila, I do understand Mr. Jamal Ansari means solicitor, not solicitaria. Okay, I will take easy, brother. Next question. Hi, brother. If you receive certificate of application under EU SS, what would be will get status? Would be you will get status? Yes. Thank you very much, Musa, for your question. Certificate of application is an acknowledgement letter to the Home Office that they received your application. So you need to wait. There is a reference number. If you need any urgent information, you can call to the EU Regulation Center and give the reference number. Someone will able to help you. So this is an acknowledgement letter. Hopefully, after, if you're a EU citizen, after 5 to 6 days, you will get your decision. If you are a non-EU citizen, it will take 2 weeks. If there is an issue, there is a not sufficient evidence you provided for your relationship or for a proof of residence, then you should log on and upload more documents. Normally, you don't need to do anything. If the Home Office need, they will send you an email to upload your evidence. Thank you very much for your question. Atakan brother asked me, sir, I face discrimination since 2015 with evidence in cricket. I selected for 3 years in Pakistan district cricket team. I have proof that team coach personal with me and did not give me the match. I want asylum. Thank you, Atakan, for your question. Asylum grounds is your grounds is not within the definition of refugee. If someone face discrimination on a body of your home country, you cannot seek asylum in the UK. The grounds for asylum, I will refer you is Article 1A of Refugee Convention 1950. In that said, if any person who own fear of prosecution because of his belief, because of membership in a particular group, because of any political opinion, because of his religion, because of his sex, because of his race, because of his color, and he unwilling to return to his home country because of you fear that he will face prosecution in his home country. Then someone can seek asylum. I'll come back again after take one question. Hello?
Hello?
Go ahead. Please ask a question.
Yeah, I have a question for Solicitor Suhail.
Yes, Madam Solicitor Suhail speaking.
Can I say my question?
Yes, please.
Okay, my question is that I'm a British citizen. I'm living in Portugal, and I'm registered there as EU citizen, and I'm exercising treaty rights. I want to. Can I bring my parents to UK for the EU settlement, or to live with me after in 2021 or maybe in 2022? Will they need any visa? My parents are non-European, and at present they are not in Portugal, but I will be calling them to live with me in Portugal, and then they will live with me while I work there. Can I bring them in future to UK with me? So this is my question.
Okay. Madam, drop your question, drop your call, and I'll give your answer live. This is a very important question.
Sorry, your voice is breaking.
I say I drop your call and I'll give your answer live.
Please, can you repeat, sir?
Okay. Can you off the line? Can you drop your call and I'll give the answer?
Okay, because I can't hear you. And
Okay.
Can I leave you a WhatsApp message?
No, I understand your question. Okay. Watch my program live and I'll give your answer.
So your voice is breaking. I really can't hear what you are saying at all.
Okay. Continue to listen my program. I'll give your answer live.
Okay, I will.
Thank you, Madam, for your question from Portugal or somewhere in Europe. This is very important question. And the sister who called me. Hello?
Hello?
Yeah, I got your question. I'll give your answer. Okay?
Okay, I can hear what you are saying is that you got my question.
Yes, I got my question. You can drop the call with me and I'll give your answer live.
Okay, I will drop and listen to the video now.
Thank you.
Okay.
Thank you very much for your question. This is a very important question. I think many British nationals who are exercising treaty rights in Europe will be benefited from this question if you need. British citizen who exercise treaty rights in Europe, any European country, they can exercise treaty rights in the UK as well as a EU citizen, not as a British citizen. For example, EU citizen can bring their family member under the EU law in Europe. It is very easier. In UK, British nationals cannot bring their further parents, dependent parents, although there is a rule, but it's very difficult. However, they can bring their their family member in Europe under the EU law, which is more easier for them. Now the question is, if that British citizen want to bring their parents in the UK under the EU law, can they bring them? The question is yes. There is a case, and very reputed case, and this case is called Surinder Singh case, and this applicant was also an Indian national who used to work in Netherlands. He was a doctor. He brought his parents in Netherlands under the EU law, and when he tried to bring them in the UK authority refused. But his argument was, well, I'm exercising treaty rights, and accordingly, I have right to bring my parents in the UK under the EU law. The European Court of Justice has accepted his argument. That is a long history anyway. And then British national, those who exercise treaty rights in Europe, they can bring their family member in the UK under the EU law rather than the British law, national immigration law. So you call me from Portugal that your parents will be in Portugal. Your question is, can you bring them in the UK? Your question, yes, you can bring your parents in the UK under the Surinder Singh case, but make sure you make an application for them as soon as possible, because there is a time limit. If your relationship start before 31st December, then that time limit is for next 2 years. I advise you, this time limit was in 31st December before, because 31st December Surinder Singh route supposed to be closed, but Home Office update and extend some time period. So I advise you to have a look the time limit again in from the Home Office website, because it's constantly changing. You said that your parents is still not in Portugal, so first bring them Portugal and then immediately make an application under the EU settlement scheme for under the Surinder Singh case route. So do it as soon as possible. I hope you will able to bring them in the UK as well. Once you bring them under the EU law in Portugal, you will able to bring them in the UK, but do it as soon as possible. Thank you very much for your question. Next question, Dubila Max. If an asylum seeker get married to British citizen, can get ILR, or how long it will take? If an asylum seeker married British citizen, he will not get asylum, but he may get limited leave to remain under 10-year rules or 5-year rules. Following completion of 5 years rule or 10 years rule, the applicant or the asylum seeker will get indefinite leave to remain if he satisfy the other requirements, such as English language requirement B1 or life in the UK test. Thank you very much for your question. Next question. Salman Aslam. Sir, first of all, I would like to thank for your dedicated, your precise time and sharing professional knowledge with us. Thank you very much. You make me happy and smile. My question is, I'm working as a system administrator in Italy. I have indefinite residence permit for Italy called Carta, I cannot pronounce next one. Can I come to UK on work permit on a types of visa, on any types of visa? Thank you very much, Salman Aslam, for your wonderful comment and wonderful question. Brother, the Home Office introduced new point-based immigration system, which is introduced a skill worker for the people who are skilled on a particular subject, particular field. Like yourself, you are an IT administrator. Probably you will have a chance to get a work permit visa. But what you have to do, you need to find an employer in the UK who will sponsor you. The eligibility requirement is 70 points. If any company offer you a job who is licensed by the Home Office, you will get 20 points. If the job at a skilled job, which is your field, IT administrator, you'll get 20 points. If you can speak English, you need to provide a B1 certificate, you will get 10 points, 50 points mandatory. And if the wages of your job offer is £25,600, you'll get another 20 points, means 70 points. You will get work permit in the UK. Brother, you got already indefinite leave to remain in Italy. If you come to the UK, you need to complete next 5 years in the UK, then you will get indefinite leave to remain. And after 1 year of indefinite leave to remain, you will get British passport. I would advise you, brother, take little more time, get Italian passport. Once you get the Italian passport, your life is settled in Europe. You don't need to wait another 5-6 years to get British passport. Once you get the Italian passport, then find an employer and you will start work in the UK. This will be best decision for you, brother. Thank you very much for your question. And the next question. Muhammad Ali, Assalamu alaikum. How long take time spouse visa? Spouse visa, brother, normally 2 weeks. If you apply someone in from home back home, 2 weeks. If from the UK, 4 months, 6 months. So if you, I don't know what you answer. If you ask me that how long it take to get decision from the home office, that will be your answer. Abraham Sharif, what is the time limit for any EU citizen in the UK that want to bring family member to UK? There is no time limit for EU citizen in the UK to bring their family member in the UK. However, due to the Brexit, the time limit is as soon as someone get pre-settled status, they can invite their family member before 2025, subject to certain condition and certain circumstance. So you can seek an advice, what is your circumstance, and then you will get your right information. Thank you, brother. Thank you, viewers, for all of your lovely question and support. I was not able to give everyone answer, but inshallah, if I get next session, get an opportunity, I'll try to give your all your answer. And please share this video in your timeline if you think this will be benefit our community. Everyone have a very good evening again, and bye for today here.